afternoon. My name is Alena Shautsova. I am an immigration attorney from Brooklyn, New York. I would like to have today's legally speaking seminar on special immigrant juvenile status. It is very important that we try as practitioners and as advocates for children to spread the news that children who are unaccompanied or children who are separated with both or one parent, and by children I mean usually children under 21 years old, may qualify for green cards in the United States without the need of applying for asylum. How does it work? Well, it's a two-step process. The first step has to be accomplished in a state court where the child resides, and here where it might be tricky. A child in New York is a person under 21 years old, but in some other states, the child might be regarded as such only when the person is under 18 years old. So the child has to go to a family court where he or she resides and ask for a petition if the child is over a certain age, or a petition has to be filed by on child's behalf by a guardian. And basically, the child or the guardian are asking that the family court appoints a guardian for the child, somebody who will oversee the child's actions in the United States. This is not an adoption process. This is a mere request to be appointed as a guardian and supervise child's life or existence in the United States. There are no financial obligations as a result of this appointment, and no new relationship as adoption will be created once the guardian is appointed. Once the court issues, a family court, a local state court issues an order appointing a guardian, then the child may file a petition with USCIS asking for special immigrant juvenile status. And now it is very important that the child files such a petition before child's 21st birthday. Even if the child ages out, let's say the child's birthday is December 31st, he or she files a petition on December 25th and is accepted on December 26th by USCIS. On January 1st, the child is already 22 years old, but it doesn't matter. As long as the child managed to file his or her petition before the 21st birthday, USCIS will consider such a petition. Now there is a little catch. As always, certain countries exhausted quotas for the special immigrant juvenile visas, and those countries are El Salvador, Honduras, if I'm not mistaken, Ecuador, and there was one more, I believe, Guatemala. So children from these countries may submit their petitions, but they will not be adjudicated up until the new quotas for such green cards will become available. But it doesn't mean that the applicants have to wait. They have to act. They still have to submit the applications so that they will preserve their deadlines for the applications. In case the green card application is approved, the child becomes a green card holder and later may apply for United States citizenship if the child, or at that point an adult, would wish to do so. The only catch to this is that the child who receives a special immigrant juvenile status cannot sponsor his or her parents into the United States. I hope this little video was helpful, and I hope that if you know of children who need immigration help, you will use this in helping them and staying safely in the United States. Thank you.